fresh matter. Huh? You know, fresh matter. Huh? Huh? ಹಾಕಿದ್ದೀರಾ? Yes. Yes.
Order CL number 1, Charan Basappa K. Bob Shetty.
Huh? To make arrangement for representation of this case along with intimation letter R1A to C. ಏನಿದು? Huh? ವಕಾಲತಲ್ಲಿ ಬೇರೆಯವ್ರ ಹೆಸರಿಲ್ವನ್ರಿ? ಮಿಸ್ಟರ್ ಅವರ ಕೊಲಿಗ್ ಗಣೇಶ್ ಅವರ ಹೆಸರಿಲ್ವಾ? ನೀವು ಇದ್ದೀರಾ? ಹಾ, ಏನು? ರೆಸ್ಪಾಂಡೆಂಟ್ ವಕಾಲತ್ ನೋಡ್ರಿ. ಹಾ, ಒಬ್ಬರೇನು? But we are not going to issue court notice. I don't follow that system. It is up to you. A memo dated 8/2/2024 has been filed on behalf of response number 1A to C. One A and C ಇರಬೇಕು. 1A and C. Stating that learned counsel Shri Amit Kumar Deshpande, who was earlier on record, has been designated senior counsel, and therefore information has been sent to the party to make necessary arrangement for proper representation before the court. Full stop. Next para. It is for the learned counsel to ensure that proper arrangements are made. This court is not going to issue court notice in such matters. Full stop. Release this matter on 25th of November.
CL number 2, SS Mandapur.
Huh? Refused. R2C, R3. Notice sent to response number R2 bracket C and R3 I have returned with postal shara, did not come, refused. Close and comma, full stop. Therefore, notice is held sufficiently served on response number so and so. Stop. Next para. A week's time is granted at the request of learned counsel for the appellant to take fresh steps for service of notice on the unserved respondents. 2 weeks. Yes.
CL number 3. Preeti Patil Milkundi.
Huh? A week's time is granted at the request of learned counsel for the appellant to furnish correct address and to take steps for service of notice on respondent number 5. ಇದು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಹಾಕಿಲ್ವಲ್ರಿ ನೀವು? ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ. The appellant is also required to furnish the acknowledgement for having deposited 50% of the award amount, before the next date of hearing.
CL number 4, government advocate.
Office objection is overruled. Notice issue ಆಗಿದೆ.
ಸಂಗನ ಬಸವ ಪಾಟೀಲ್
ತೋರಿಸಿದ್ದಾರೆ. ಸಂಗನ ಬಸವ ಪಾಟೀಲ್. ಇನ್ನೊಬ್ರು ಇದಾರಾ? Issue notice. Learned counsel Shri Sangan Basava B. Patil has entered appearance for response number 1 and 3. Issue notice to respond number 2. Condone ಮಾಡಿದ್ರು. ಇಲ್ಲ. All those, we have said that issue will be kept pending. We have not dismissed the appeals. ಆಯ್ತು ಬರ್ಲಿ ಎಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಒಂದು ಇದರಲ್ಲಿ. Yes. Once we take that kind of a decision, then all this can be disposed of. Yes.
CL number 5, Mahesh Patil.
Non-filing of better affidavit by government advocate. ಕೊಡಿ. ಅಂಗನವಾಡಿ ವರ್ಕರ್ ಅಂಗನವಾಡಿ ವರ್ಕರ್ ಅಲ್ಲಿ ಕಂಪ್ಯಾಷನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇದೆಯಾ ಪ್ರಾವಿಷನ್? Yes. Hmm. Yes, what is your contention? ಅಲ್ಲ ಡಿಲೇ ಬಿಡಿ. ಆಯ್ತಮ್ಮ, ಗೈಡ್ಲೈನ್ಸ್ ಅಲ್ಲಿ ಇದೆ. The learned single judge has held that it will be contrary to Article 14. See, you should be aware of the latest developments. More than 2 years ago, such issue was raised, and a learned single judge in the principal bench held that you cannot keep away married daughters. So therefore, ಅದಾದ್ಮೇಲೆ you have changed your rules only. So therefore, have you come with any judgment, any decided case, or what is it? ಮತ್ತೆ learned government advocate submits that the respondents in the contempt petition have filed a writ appeal which is connected along with the contempt petition. Full stop. Learned additional government advocate submits that the learned single judge has allowed the writ petition despite the fact that the guidelines governing the compassionate appointment of Anganwadi workers clearly stipulate that a stepson or a stepdaughter will not be entitled to claim compassionate appointment. Full stop. Learned AGA submits that except stating that such a clause is illegal and contrary to Article 14 of the Constitution of India, nothing else has been said in the impugned order. Full stop. Next para. Matter requires consideration. Full stop. Consequently, delay of 235 days in filing the appeal is condoned. Full stop. Next para. Learned counsel for the complainant and the learned AGA are directed to come prepared to address the court regarding the issue raised in the writ appeal. Please come prepared. ಇದರಲ್ಲಿ learned delay condone delay ಮುಂಚೆ learned counsel ಶ್ರೀ Mahesh Patil is requested to take notice for the respondent in the writ appeal. Learned AGA is directed to serve a copy of the appeal memo along with annexures on the learned counsel for the respondent. Lastly, release this matter on 25th of November. Please come prepared.
Serial number 6, Nitesh Padiyar.
ನೀವು writ appeal prepare ಮಾಡುವಾಗಲೇ grounds ಅಲ್ಲೇ everything should come. Otherwise, what is the use? You should have made some research and you should have put the legal grounds. What is the use of simply filing a writ appeal without there being legal grounds? That should not happen. Adunu, there is a delay of more than 235 days. You had sufficient time. Yes.
Already filed and compliance report long back, my lord. So, 4 to 5 times it is urgent, my lord. After compliance, my lord, every time they are.
One name. Which is the order?
Please.
ಸ್ವಲ್ಪ ಇರ್ರಿ.
Order is at an page number. It is
Annexure A.
please. May I read, my lord?
Please read the first paragraph.
Please, my lord. The present petition filed seeking a direction to issue mandamus directing the respondent to, particularly respondent number 6, to pay 16th month salary of the petitioner from February 2022 to May 2023. Further issue direction increase the salary of 3% per month from 25th for 25 months from 21/5/2021 to till date, and also payment of TADA for 46 months as per the representation of the writ petitioner dated 6/4/2002, which is filed at annexure F, my lord.
Now let us come to the operative portion.
Please, my lord. Accordingly, writ petition disposed of disposed of by directing the respondent, particularly respondent number 7, to consider the representation of the petitioner dated 6/4/2023 and consider with law when this court direct the respondent to consider the representation, it is not formality. The respondent shall consider the representation within period of 4 weeks from the date of receipt of the copy of the order, my lord.
Now you
After
have
this, my
considered
lord.
and
After this, my lord, we are considered and hold an inquiry, my lord. Even we are issued a notice to the complainant and he is appeared. We are passed in detailed order. Whatever pending arrears we are already paid, that was also placed in annexure R1, my lord. We are categorically stated that, my lord. Claims of the petition. May I read, my lord?
yes.
At page number 5. This is the case of consideration of representation, my lord. And after considering entire representation, passed in detailed order, not
On 18/9 it was filed.
ಅದಕ್ಕಿಂತ ಬಿಫೋರ್ ಕಂಪ್ಲೈನ್ಸ್ ಕೋರ್ಟ್ ಮುಂದೆ ಅಲಾಂಗ್ ವಿತ್ ಮೆಮೋ ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ಕೋರ್ಟ್ ಅಫಿಡವಿಟ್ ಹಾಕ್ರಿ ಅಂತ ಹೇಳಿದ್ರು. 89 ಇಟ್ ಅಫಿಡವಿಟ್ ಫೈಲ್ಡ್ ಮಾಡ. ಬಿಫೋರ್ ದಟ್ ಆಲ್ಸೋ ಓನ್ಲಿ ವಿ ಆರ್ ಕಂಪ್ಲೈನ್ಸ್ ರಿಪೋರ್ಟ್ ವಿ ಆರ್ ಫೈಲ್ಡ್ ಅಲಾಂಗ್ ವಿತ್ ಮೆಮೋ. ಅವಾಗ್ಲೂ ಅವ್ರು ರಿಜೈಂಡರ್ ಹಾಕ್ತಿವಿ ಅಂತ ಹೇಳಿದ್ರು. ಆಮೇಲೆ ಅಫಿಡವಿಟ್ ಹಾಕ್ರಿ ಅಂತ ಹೇಳಿದ್ರು. ವಿ ಆರ್ ಫೈಲ್ಡ್ ಅಫಿಡವಿಟ್. ಅಫಿಡವಿಟ್ ಆದ್ಮೇಲೂ ಒಂದು ಡೇಟ್ ಆಯ್ತು.
Learned counsel for the respondent submits that a memo along with affidavit of complaints was filed before this court on 18/9/2024. Stop. The matter was adjourned at the request of the learned counsel for the complainant. Full stop. On 24/9/2024, again, the matter was adjourned to enable the complainants to file rejoinder if any. Full stop. Next para. Learned counsel for the complainant submits that the rejoinder is ready and the same will be filed by 11th of November, Monday. Release this matter on 14th of November. 14th. 14th of
14th.
November.
Grateful.
CL number 7, government advocate.
But in this case, submission, it is regarding office objection number 5, which says that the notification date is to be clarified. We have clarified the date of 4/2/2014, which is appearing in the award, my lord.
Office objection is overruled. Learned counsel Shri Sanganambasava B. Patil has entered appearance.
R1.
Huh?
R1.
Operator.
Only for the respondent. Obretane, claimant.
Operator.
You have a copy of the appeal memo?
Copy, I'll furnish. I will furnish. Okay.
Yeah. Stop. You are asking for stay.
That is regarding delay aspect, my lord. So that will be considered.
There's
That
a
is
delay.
kept pending. That's what.
Huh? What have you done in that other matters? Huh? Release this matter on 12th of November. Huh? Aduna, serial number 4, no, release this matter on 12th of November. Yes.
CL number 8, Puneet Markle.
Round seal not forthcoming. Office objection is overruled. United India Insurance. Learned counsel Srimati Anuradha and Desai is requested to take notice for respondent number 2. Learned counsel for the appellant has filed a memo seeking dispensation of notice to respondent number 1 on the ground that respondent number 1 is the owner of the vehicle and the liability has been fastened on respondent number 2 insurance company. Full stop. Next para. At the risk of the appellant, notice to respondent number 1 is dispensed with. Learned counsel for the appellant is directed to serve a copy of the appeal memo along with annexures on learned counsel for respondent number 2.
Hearing one.
Refer madbeka? Lokadalat. Matter stands referred to local. Delay idea. Nenne ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದೀವಿ ನಾನು. Delay condoned subject to condition that the appellant will not be entitled for interest during the delayed period. Yes.
Refer to local.
Yes.
Hearing one is CL number 9, BM Geraldine.
2013. Huh? 2013 dismiss. ಅಲ್ರಿ ಅದನ್ನ ರಿಯಲೈಸ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಎಷ್ಟು ವರ್ಷ ಬೇಕು? ಸೊ ಅವರು ಸುಮ್ನೆ ಕೂತ್ಕೊಬೋದಾ? ಅವರು ಸುಮ್ನೆ ಕೂತ್ಕೊಂಡ್ಬಿಡ್ಬೋದಾ? There should be some reasonableness, sir. That will not be sufficient ground. ಅವರೊಬ್ಬರದೆಲ್ಲ ಜವಾಬ್ದಾರಿ, ನಿಮ್ದು ಇದೆ. ಅಲ್ಲ ನಿಮ್ದು ಅಂತಂದ್ರೆ ಐ ಆಮ್ ರೆಫರಿಂಗ್ ಟು ಎ ಪಾರ್ಟಿ. ಹಾ ಹಾ
ರೆಸ್ಟೋರ್ ಆಗಿದೆ.
ಒರಿಜಿನಲ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನು ಅಂತ ನೋಡ್ಬೋದು. ಇಲ್ಲ, IA ಫಾರ್ ಕಂಡೋನೇಷನ್ ಅಲಾಂಗ್ ವಿತ್ ಫುಲ್ ಕಾಸ್ಟ್ ಟೈಟಲ್. ಅಲ್ಲೂ ಡಿಲೇ ಇತ್ತು, ಅಲ್ಲೂ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ ಫಾರ್ ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ. ನಿಮ್ಮ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ದಾಗ there is no application for condonation of delay.
ಡಿಲೇ ಇಲ್ಲ,
ಡಿಲೇ ಇದೆಯಂತಲ್ಲ,
MFA ಡಿಲೇ ಇದೆಯಲ್ಲ,
ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ. ಏನ I'll pick up the 11 years.
Interest without interest for entity.
Liability is fastened on the insurance company, is it? Huh? ಮಾಡಿದಾರಾ? Enhancement. When was it satisfied? ಯಾವಾಗ? ಅವ್ರು ಬಂದು serious objections raise ಮಾಡ್ತಾರೆ. See, even after taking the compensation amount, even at that point of time, you didn't realize that nothing has happened in the appeal. Learned counsel. Srimati Preeti Patil, Melkundi, is requested to take notice.
ಇದ್ರ ಅಮೌಂಟ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ತಗೊಂಡಾರ. 10,000 ರೂಪಾಯಿ ತಗೊಂಡದ. ಇದ್ರಾಗ ಏನಿಲ್ಲ ಬಿಲ್. 6,000 ಇನ್ಕಮ್ ತಗೊಂಡದ. 6,000 2010 ಆಕ್ಸಿಡೆಂಟ್ ಇರೋದು 2,000 ಇನ್ನ 500 ರೂಪಾಯಿ ಜಾಸ್ತಿ ತಗೊಂಡಿದ್ದಾರೆ. ಅಲ್ರಿ ಲೋಕಲ್ ಚಾರ್ಜ್ ಪ್ರಕಾರ 5,500 ರೂಪಾಯಿ ಐತಿ. ಈಗ 6,000 ರೂಪಾಯಿ ತಗೊಂಡಿದ್ರೆ
ನೋಡ್ರಿ 500 ರೂಪಾಯಿ ಜಾಸ್ತಿ ತಗೊಂಡಿದಾರ ಅಲ್ಲಿ ಚಾರ್ಟ್ ಕಿನ್ನ. ಅವರು let them come and raise it. Is requested to take notice for respond number 2. Learned counsel for the appellants is directed to serve copies of the appeal memo and IA number 1 and 2 of 2024 on learned counsel for respond number 2. Release this matter on 19th of November. Huh? ಏನು ಬರ್ತಾ ಇಲ್ವಾ? ಹಂಗಾದ್ರೆ ಇವರು ಸುದರ್ಶನ್ ಎಂ ಸುದರ್ಶನ್ ಪ್ರೀತಿ ಪಾಟೀಲ್ ಅವರು ತೆಗೆದ್ಬಿಟ್ಟು ಸುದರ್ಶನ್ ಎಂ ಅಂತ ಪ್ಲೀಸ್ ಗಿವ್ ಕಾಪೀಸ್.
Please.
You please take instructions and
Yes.
There is a huge delay of 11 years.
Yes, yes.
Huh?
I will take.
Please take instructions and you can argue on the application.
Yes.
Yes.
Please.
CL number 10, BM Jirli, Kausalgi Chandrakant, CL number 10.
Huh? 9 and 10.
Same. CL number 11, Subhas Mallapur,
ಇನ್ನೊಂದು 10
CL number 11, Subhas Mallapur,
1444 days delay. Huh? Claimant insurance company. Insurance company. Huh?
DL ಇಲ್ಲ ಅಂತ ಇದ್ ಮಾಡ್ಯಾರ ಬಟ್
ಹೌದ್ರಿ But why is there such a long delay? Huh? ಅಲ್ಲ ಯಾವ್ದಾದ್ರು ಆಗ್ಲಿ ರೀ. It should have gone before single judge. ಇದು dismiss ಆಗಿದೆಯಾ? But the matter was supposed to have been listed before learned single judge ಅವರು. Nine three.
Dealing. Dealing from other than.
Huh? So it should have gone before single judge. Then why is it that it is dealing with the other, the above appeal is dismissed on 9/3/2018. ಈ ರೀಕಾಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದ್ರಲ್ಲಿ ಡಿಲೇ ಇದೆ. There is a delay of 1,444 days in filing the application for recall of the order dated 9/3/2018. Full stop. However, learned counsel for the appellant submits that this matter should have been listed before learned single judge, having regard to the pecuniary jurisdiction. Full stop. Office to verify. Next para, office to verify. Note shall be put up by the office as to whether the matter is required to be placed before learned single judge. Full stop. Release this matter. Then why is it that it was placed before a division bench?
ಅದು ಬೇರೆಯವರು ಇರ್ತಾವಲ್ಲ ಅದಕ್ಕೆ ಬಂದಿದೆ. ಅವಾನ ಡಿಸ್ಪೋಸ್ ಆಗಿ ಬಂದು ಕನೆಕ್ಟೆಡ್ ಡಿಸ್ಪೋಸ್ ಆಗಿ ಡೀಲಿಂಗ್ ಇದಾವ ಇಲ್ಲಿ ಡೀಲಿಂಗ್ ಅಂತ ಮಾಡ್ಯಾರ. ಮೊದಲು ಇದು ಬೇರೆ ಕೇಸ್ ಇದ್ದು ಅದ್ರ ಆರ್ಡರ್ ಆಗಿದೆ ನೋಡ್ರಿ, ಅದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. ಇದೊಂದೇ ಇದ್ರೆ
ಯಾರ ಮುಂದೆ? ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ ಸಿಂಗಲ್ ಜಡ್ಜ್
ಅಲ್ಲಿ ಇಲ್ಲಿದೆ ನೋಡ್ರಿ ಚೆನ್ನಾಗಿ.
You also should be knowing, sir, if there are connected matters, office is also directed to furnish information as to whether the connected appeals in MFA 201223 of 2015 and 200781 of 2015
EPI ಏನೋ ಸ್ಯಾಟಿಸ್ಫೈ ಐತೆ ನೋಡ್ರಿ ಅಮೌಂಟ್
were disposed of before the division bench or the learned single judge. Next para, release this matter on 14th of November. Let them give the information, we'll see. Yes.
Seal number 12, Ratna and Shoyogi.
ಇದನ್ನು ಬರ್ಕೊಳ್ಳಿ. Learned counsel for the appellant is also directed to secure information as to whether the award amount has been satisfied in the other cases. Yes.
Seal number 12, Ratna and Shoyogi.
at the request of learned counsel for the appellant, release this matter on 13th of November.
Seal number 13, Praveen Kumar Raikote.
Lords, I appear for the appellant in the matter.
Recalling order dated 30/11/2022.
Application was filed within time. Thereafter, this honorable directed to comply with the office objections, and we have complied with the office objections and wrote.
Then the matter has to be placed before Lordship Justice K.S. Mudgal.
Non-compliance in dismissal.
Re, the order kandre.
I understand, madam. But your lordship could also exercise.
Non-compliance, it can be placed before any other.
Yes, madam, yes. Madam.
Four 4/7/2023 you are permitted to comply with the office objections. Yenaito.
I am told, but it has been done, my lord, after that.
The counsel for appellant has complied with office objections. Pandidiyal, right? Office objections have been complied. Barkal. Order on IA number 1 of 2022. This application is filed by the appellants seeking to recall order dated 30/11/2022, whereby the appeal was dismissed for non-compliance of office objections. Full stop. After the application was filed, this court, by order dated 4/7/2023, permitted the appellants to comply with the office objections within 2 weeks. Accordingly, office objections have been complied. Full stop. Next para. Consequently, the order dated 30/11/2022 is recalled. Full stop. The appeal is restored. Full stop. List this matter for admission on 19th of November.
Please, madam.
Seal number 14, Harshavardhan R. Mali Patil.
Do not 7 days delay. Matter can be referred to Lok Adalat.
The claim petition was dismissed. The claim petition itself.
Claim petition dismissed. Notice issue ಆಗಿದೆಯಾ?
A delay may be continued.
Allari, are you ready?
No, I will go through, once I will go through the, a date will be fixed.
Order on IA number 1 of 2019. There is a delay of 207 days in filing the appeal. Full stop. The claim petition filed by the appellant has been dismissed. Full stop. Learned counsel would therefore submit that the delay may be condoned while imposing conditions on the appellant. Stop. Next para. Accordingly, delay is condoned subject to the condition that the appellant shall not be entitled for interest during the delayed period. Full stop. Yes.
Seal number 15, additional government advert.
The appellant, related matters are posted on 12th.
Huh?
Related matters are posted on 12th regarding.
Well,
delay
release
as-
this matter on 12th of November.
Seal number
ಅದನ್ನ ಗೊತ್ತಲ್ಲ ನಿಮ್ಗೆ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ಡ್ ಬೈ ಲಾರ್ಡ್ಶಿಪ್ ಜಸ್ಟಿಸ್ yes yes
Seal number 16, additional government advocate.
So in this case, the matter was posted on 23/9/20, 26/10/23 before ARJ for compliance of office objection. Since on that day, the objections were not complied and so it was dismissed, my lord, filed application for recalling the order dated 26/10.
you are permitted to comply.
It is
ಆಗಿದೆಯಾ?
complied. For filing this application, there is a delay of 281,
Delay of
281 days.
order on IA number you have been specifically saying because a technical issue is raised, keeping it open. You have consciously said, yes, we are keeping it open, it will be considered. Order on IAS number 1 and 2 of 2024. These applications are filed by the appellant seeking to recall order dated 26/10/2023, while also seeking condonation of delay of 281 days in filing the applications. Full stop. By the said order dated 26/10/2023, the registrar bracket judicial dismiss the appeals for non-compliance of office
Office
objections.
objections.
Full stop. However, after filing of these applications, the appellant was permitted to comply with the office objections. Full stop. Accordingly, office objections have been complied. Full stop. Next para. Consequently, while condoning delay, the applications are allowed. Full stop. The appeal is restored to its original file. Full stop. Next para. List this matter for admission.
Delay.
Same, but posted on 12th.
That can be done only in the presence of the other party. That can be done only in the presence of the other party.
Yes.
Release this matter, Allah, sir, list this matter for admission on 20th of November.
Okay.
Serial number 17, Vishal Pratap Singh.
My lords, the question of juvenility that I have to file an objection to that effect, my lords. Still I haven't received this thing. 1 week accommodation may be granted. 19th it would be. It could be posted on 19th.
Finally, comma, at the request of learned counsel, learned additional SPP, release this matter on
19th.
19th of November.
Please.
Serial number 18, Vishal Pratap Singh.
Objection is. But objection is ready, my lord. I am
Learned,
filing a objection.
Additional SPP submits that the objections to IAS number 2 and 3 are ready.
Yes, ma'am.
Full stop. Learned additional SPP is requested to serve copies of the same on the learned
Yes, ma'am.
counsel for the appellant and file the objections in the office.
Yes,
Please file in the office.
please.
Relist this matter on 13th of November, Wednesday.
13th, bada ive, sir.
Huh?
More matters are there, my lords. The 19th would be,
Sorry, IA alva.
aye, this, but it's a big matter, my lords. It could be posted on same 19th.
Huh?
19th it could be posted.
19th.
19th on the same day. Both be heard on the same day. Sir.
19th.
There is a recommendation from the management early 2014. She can be accommodated instead of regular school.
Serial number 19, Harsha Shetty.
My lords, I appear for the petitioner, my lords. This is a case of a lecturer.
Notice for respondent 4 and 5. Since there is an application for delay also in this matter,
Only 2 days delay. my
I'll be filing my objection for interim application for interim orders, other interim orders. I'll file my objections.
Only-
ನಿನ್ನೆ yesterday serve ಮಾಡಿದ್ದಾರೆ. They have served the copy on me yesterday. So today I have.
Learned counsel Shri Shivanand Patil.
I'll take notice for 4 and 5.
Who had filed caveat on behalf of respondent number 4.
4. 5 is the principal of their college.
That, he has received copy of the appeal memo yesterday. Full stop. He would also undertake to appear for respondent number 5.
5.
Full stop. Learned counsel seeks for a short accommodation to make his submissions, to file objections
And make submissions.
to the interrogatory applications.
IA 4.
IA number 4.
IA number 2, sorry, I'm sorry. IA number 2.
IA number 2 of 2024. And make his submissions. Full stop.
But there is a 2 days delay in my lords filing.
Next para. Delay of 2 days in filing the appeal is condoned. Full stop. List this
Yes.
matter.
I accept
To hear
notice for
on-
respondent 1 to 3.
IA number 2 of 2024 on 13th ಆಗ್ಬೋದಾ?
ಆಗ್ಬೋದು.
13th of November.
No.
ಮುಂಚೆ learned government advocate takes notice for response number 1 to 3. Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned government. Yes.
Please.
Serial number 20, government advocate.
In this case, the notice.
Learned counsel Shri Harshavardhan Malipatil, who is present in the court, undertakes to appear for the respondent claimants. 2 weeks' time is granted to file wakalat. Learned government advocate is directed to serve copies of the appeal memo on the learned counsel for the respondent claimants. Yes.
Plenary, serial number 21, VK Nayak.
You want interim orders in this matter? Delay is only 42 days.
42, it is within 120 days. no? The stay must
Serial number 21.
Already serial number 20.
20. no?
Delay is only 42 days.
Yes, yes,
Huh?
yes.
You
Stay
are
may
not asking
subject.
for stay?
They are seeking stay with conditional deposit and with
ಅಲ್ವಾ?
indemnity. yes.
So same orders, ಬೇರೆದ್ರಲ್ಲಿ ಮಾಡಿದೀವಲ್ಲ, less than 120 days.
Yes.
Huh? ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. Same orders. Yes.
Seal number 22, we can add.
Interim order. Ian, what is annexurial? They were reinstated back. Huh? You are deputed by order dated 7/12/2022. What is wrong? You please go and bring it to the notice of the learned single judge. We will see. Issue notice to respond number 1. Learned government advocate is requested to take notice for respond number 2. Learned counsel for the complainant is directed to serve a copy of the petition on the learned government advocate. Yes. Yes.
Seal number 22, Mahantesh Patil.
Lord, one kind submission. In connected appeal, my lord, there is only one objection left out, my lord. Annexures back to back, my lord, which are filed in, my lord, writ petition is in, my lord, objected by the, my lord, scrutiny office.
You have filed writ appeal.
writ appeal, my lord.
Ah.
In that, my lord, there is only one annexure, my lord, I mean objection.
Non-compliance of office objection.
Lord, annexures are back to back page, my lord. Office objection number 5, my lord.
5 matra.
5 matram.
ಇದೆಲ್ಲ comply ಆಗಿದೆ.
Other things, my lord, complied.
WP all annexure to be furnished in a fresh page.
Single page,
Ta.
the fresh page ಅಂತ ಇದೆ.
Office objection at
Please.
serial number 5 is overruled.
Please.
Yes. Huh? Learned counsel. Shri Mantesh Patil takes notice for the respondent in the writ appeal. Huh?
Please.
Learned for the appellant is directed to serve copies of the appeal memo along with annexures on learned counsel for
I
the
will.
respondent. Release these matters on 21st of November.
Much.
CL number 23, Ravi B. Patil.
Appeal ಆಗ್ತಾರೆ ಅದ್ರ ಇದ್ರ ಮೇಲೆ. Learned government advocate takes notice for respondent number 1. Issue notice to respondent number 2. Learned counsel for the complainant is directed to serve copies of the petition along with annexures on the learned government advocate. Issue notice to respondent number 2 returnable by 25th of November. That deeming provision comes with a stipulation subject to the condition that all other requirements are fulfilled. The contention is that it's a tenanted land, it cannot be converted. Anyway, let us see.
Admission matters, CL number 24, Anand Pure.
My lord, parties.
Huh?
ನಮ್ ನಮ್ಮ ಪಾರ್ಟಿ ಬರ್ತಾ ಇದಾರೆ ಮೇಡಮ್, ಮೇ ಬಿ ಕೈಂಡ್ಲಿ ಪಾಸ್ ಅವರ್ ಮೇಲೆ
ಬರ್ತಾ ಇದಾರ
ಬರ್ತಾ ಇದಾರೆ ಮೇಡಮ್. ಸ್ವಲ್ಪ ಏನೋ ಬಸ್ಸಲ್ಲಿ ಡಿಲೇ ಆಯ್ತು ಅಂತ ಬರ್ತಾರೆ.
ಆಗುತ್ತಾ ಇವತ್ತು?
1 hour ಅಲ್ಲೇ ಬರ್ತಾರಂತ.
ಹಾ?
1 hour ಅಲ್ಲೇ ಬರ್ತಾರಂತ.
Let us see.
Please, madam, I will take.
Possible by the end of the list, if they come, it's all right.
Please, madam.
Otherwise, we'll adjourn.
Please, madam.
Pass over.
CL number 25, Arun Kumar Amargundappa.
Sir, filing some additional documents, I'll file with registry.
Hmm?
I'm filing some additional documents.
You have filed.
Sir, I'll file registry.
You want to file this?
Yes,
Please file it in the office.
that's why I'm seeking.
Learned counsel for. Oh, there, you collected. Huh? What is the information now given? ಎಷ್ಟು collect ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ?
28 ಏನು 28 lakhs. 28 lakhs. Some change.
28 lakhs. That is why they want to place additional material on record. They are wanting to bring that on record.
I have all the sympathy.
ಆಯ್ತು ರೀ, ಕನ್ಸಿಡರ್ ಮಾಡೋಣ. Please take it. We will consider.
Please, my lord, sir.
Please. We will consider you. Please take it now.
I may appeal for the Learned Counsel for
They want to
25
find some additional document. Please collect it.
Please, we'll
Go
connect
through
it.
Then we will
Please,
hear you.
Please, we will receive it, my lords, and the lords may kindly accommodate some other day, my lord, so that we can also submit our statement.
Yes, yes. In terms of the directions issued by this court, the manager of the respondent bank has collected the amount deposited by the appellant from the registry.
Please.
Full stop. However, learned counsel for the respondent bank submits that they intend to place on record certain additional documents. Full stop. Yeah, you are filing it along with an application, or what is it? Memo?
Order 41 will concern.
Application.
Yes.
Huh? In that regard, an application is ready.
I have served the copy.
A copy of the same is served on the learned counsel for the appellant. The respondent bank is permitted to file the same in the office in the course of the day. Release this matter on 12th agboda, 12th, 13th, 14th.
Any day, I am at my lord's disposal. Any day whichever, your lord's.
20 either.
Huh?
20.
20 ಯಾಕೆ?
Probably.
ಎರಡು ವಾರ ಮುಂದಕ್ಕೆ ಹೋಗ್ಬಿಡುತ್ತಲ್ರಿ.
The only question of calculation now, my lord, how much amount is actually due.
ನಾವೇ ಡೈರೆಕ್ಷನ್ ಕೊಡೋಣ ಬಿಡ್ರಿ. Let them come. If they want to place something on record, let them place.
Our hands are.
We will go through that one and we will instruct them.
If I give something, my lord, it is problems.
ಬರೋದಿಲ್ಲ. We'll have it on 14th then.
Please.
Release this on 14th of November.
Please, please. Great.
Serial number 26, PS Mali Patil.
Appearing for respondent.
My lord, I appear for the.
In this matter, my lordship,
Appellant in
I
this
filed the
matter.
detailed objection. Kindly week's time will be granted.
While Madhidendra, I am arguing, my lord. For its
You know?
kindly see, my lord, the order of the learned single judge. In the writ petition. And the order.
RO.
Yes. That is annexure, my
Petitioners
lord.
are owners in possession of the land in question situated so and so, so
It
and
is
so.
not, we are not concerned about the, my
And
lord,
the
possession.
name of respondent 5 work board
Work board
has
is
been
entered.
in respect of land of the petitioners in column number 11.
Yes,
Feeling aggrieved of the same petitioner herein have approached this court.
yes.
Getting up to
But I am.
having taken
kindly
note
see,
of
my
the
lord,
arguments appearing for the parties, this court directions to respond number 3 to delete the name of respond number 4 work board from the record of rights, reserving liberty to the respondent. Number 4 work board to follow due process of law for seeking change of entry in the record of rights. In that view of the matter, I am of the view that respond number 3 Tahsildar is directed to delete the entries made in the record. Now the appeal has been filed by the work board.
Work board, my
Yes,
lord,
my
my lord, my only grievance is, my lord,
Ah,
the learned single judge, my lord, would have been remanded the matter for reconsideration. The main grievance of the petitioner in the writ petition is that, my lord, that mutation was carried, my lord, without notice to them.
yes,
Yeah, and the order of what my learned, not the learned single judge has referred, not the order at page number 15, para number 4.
yes.
Para number 4, not last 3 lines. On the other hand, the respond number 4 is directed to recourse to the law for the change of entry in the record of rights. Not that
Yes.
means, not he must follow the record, not the procedure and not pass the appropriate order. That has not been done, not by the in the operative portion of the order. Only I am
But,
only concerned with
you
that.
have there has been compliance of many such orders. We have ourselves found
Yes.
that in many contempt petitions,
Yes, my lord.
the revenue authorities have complied with such orders.
Yes, my lord, they have complied, but however, my lord, the liberty may be reserved to the authorities or to the appellant to, my lord, to proceed, my lord, further in accordance with law.
ಮಾಡಿದಾರಲ್ಲ.
ಮಾಡಿಲ್ಲ ಈಗ ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ ಅಲ್ಲಿ.
No, you please see that observations in paragraph number 4 which you just read out now.
ಅದನ್ನೇ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಆಫ್ ದ ಆರ್ಡರ್ ನಲ್ಲಿ ಬಂದಿಲ್ಲ ಅದು.
He is
Yeah,
directed
para
to
number
delete
5,
the-
my lord, I will read it, my lord. The respond number Tahsildar is directed to delete the
restore
name of the
petitioners
work
in the
board
record of rights.
from the record of rights in respect of the land of the petitioner and restore the name of the petitioner in the record of right within a period of 4 weeks from the date of the receipt of the certified copy of the order.
All right, you
There
want
is
that
no further,
observation.
my lord. That
You
has
want
to
that
be-
observation.
Yes, my lord.
That
I'm
respond
only-
number 4 is permitted to take recourse of law for change
Yes.
of entry in record of rights.
In accordance with law.
Observe.
Yes.
Yes, my lordship. I filed the detailed objection.
ಇಲ್ಲಿದೆ operative portion ಇಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. This is an order passed in some other matter. ಇದನ್ನ ಇಲ್ಲಿ ಹೇಳಿಲ್ಲ operative portion ಅಲ್ಲಿ. That is what he is
ಅಷ್ಟೇ
asking.
ಅದು.
My lordship,
Liberty should be given to him to raise objections and seek entry
Yes.
in accordance with law.
Yes.
That is all he is saying.
Yes.
That is found in paragraph number 4 of that previous order, which is referred to, but in the operative portion, it is not there.
Yes, ma'am, that's all.
Learned counsel for the appellant. Karnataka State Board of Awqaf submits that this intra-court appeal has been filed only to the extent that although there is an observation made in the order referred in the impugned order, namely WP number 202385 of 2023 dated 18/8/2023, in paragraph number 4, that although the Tahsildar is directed to delete the entries made in the record of rights of the land belonging to the petitioner, nevertheless, liberty is also reserved to respond number 4, Waqf Board, to take recourse of law for change of entry in the record of rights. Full stop. This observation, however, is not forthcoming in the operative portion of the impugned order. Full stop. Para. Learned counsel for the respondents submits that he has no objection for such observation to be made in the operative portion. Full stop. Next para. Accordingly, the writ appeal is partly allowed while reserving liberty to the appellant to seek redressal in accordance with law for seeking entry of its name in the record of rights by producing relevant records to show as to how the Waqf Board is entitled to have its name entered in the record of rights. Full stop. If such petition or application is filed, comma, needless to observe, comma, that the respondents shall be notified, heard, and thereafter appropriate orders could be passed. Full stop.
Yes,
Ordered accordingly.
please, please.
Case number 27, Ravi B. Patil.
The connected appeal, I appear for appellants. My lord, last occasion, the appellants are directed to file an affidavit. File an affidavit to the effect that, my lord, they have destroyed the examination papers.
By which order?
By, my lord, order dated. Order dated 18/9/2024. Lord, I
The appellants
request,
to state on affidavit
Yes.
regarding destruction of key answers.
yes. Here is a case, my lord, complainant is
Sir?
seeking. It is, my lord, I, on behalf of,
Appellant.
yes, yes. I, in the connected writ appeal, I am, my lord, I seek, my lord, one more week time to file an affidavit. That apart, my lord, here is a case, my lord, where complainant is seeking key answers.
Key answers again ಕೊಡೋದಕ್ಕೆ ನಿಮ್
It is, my lord, pursuant to, my lord, circular and government order. Examination papers will be destroyed after 2 months of, my lord,
examination papers ಕೇಳ್ತಲ್ರಿ.
key answers, including key answers.
That will be available.
No, my lord, it is, in fact, in this case, my lord, it is not. So, yeah, otherwise, it is not so, my lord. May I request lordship to peruse annexure R1, my lord, page, annexure R1.
Anyway, you are asking for a week, one more week's time.
Yes,
So please give it.
please.
Otherwise, you will have to file a better affidavit.
Yes.
ಯಾವ ವರ್ಷದ್ದು?
2021, my lord.
How is it, it is destroyed so early?
My lord, pursuant to, my lord, orders in the KPTCL, my lord.
Huh?
There is a circular and also office order, my lord.
Why it should be
Destroyed
destroyed?
within 2 months only, my lord.
Why?
It is, my lord, this order is followed, my lord, by the earlier order issued in the year 2010, my lord.
ಎಲ್ಲಿದೆ? Where is it?
Annexure R1, my lord, page. Along with, my lord, 89 onwards. Along with statement of objections. Annexure R1. Page, I think. Page.
Statement of objections filed
By, my lord, by the respondents in the writ petition. Appellant.
ಪೇಜ್ ನಂಬರ್ ಹೇಳ್ರಿ. ನಿಮ್ಮ ಅಪೀಲ್ ತಾನ್ರಿ ಇದು?
ಹೌದೌದು.
ಯಾವ ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ?
Page. It is 89 onwards, my lord, sorry. After 89, 9. Yes. There, my lord, ಪ್ರಸ್ತಾವನೆ 27/4 ಮೇ 27/4/2010 ಹೊರಡಿಸಲಾದ ನಿಗಮ ಕಚೇರಿ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ರ ಪ್ರಕಾರ ಸಂರಕ್ಷಣೆಯ ಅವಧಿಯನ್ನು ಮೀರಿದ ಮೌಲ್ಯಮಾಪನ ಮಾಡಿದ ಇಲಾಖೆ ಪರೀಕ್ಷೆಗಳ ಉತ್ತರ ಪತ್ರಿಕೆಗಳನ್ನು ಪರೀಕ್ಷೆಯ ಪೂರಕ ಫಲಿತಾಂಶವನ್ನು ಘೋಷಿಸಿದ ದಿನಾಂಕದಿಂದ 2 ತಿಂಗಳ ನಂತರ ಶೆಡ್ಡಿಂಗ್ ಚೂರು ಮಾಡುವುದರ ಮೂಲಕ ವಿಲೇವಾರಿ ಮಾಡಲು ಆದೇಶಿಸಲಾಗಿದೆ. ಹಾಗೂ ಇಲಾಖೆ ಪರೀಕ್ಷಾ ಶಾಖೆಗೆ ಒಂದು ಶೆಡ್ಡಿಂಗ್. So it is, my lord, it deals with different aspect. And may I now request lordship to peruse page annexure R2, my lord, next.
I don't think the key answers will be destroyed. It will be available even with the person who has set the paper. This is regarding destruction of the answer scripts.
My lord, annexure R2, my lord, for a moment. There is some more clarification. Annexure R2, my lord. ಮಾರ್ಚ್ 2020 ನಡೆದ ಸಹಾಯಕ ದರ್ಜೆ ಭಾಗ ಎ ಭಾಗ ಬಿ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಹೈಯರ್ ಪರೀಕ್ಷೆಗಳ ಮೌಲ್ಯಮಾಪನದ ನಂತರ ಫಲಿತಾಂಶವನ್ನು ದಿನಾಂಕ 3/2/2022 ಮತ್ತು ಮರು ಮೌಲ್ಯಮಾಪನದ ಫಲಿತಾಂಶವನ್ನು 9/5/2022 ಘೋಷಿಸಲಾಗಿದ್ದು, ನಿಗಮದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ಪ್ರಕಾರ ಇಲಾಖೆ ಪರೀಕ್ಷೆಯ ಮರು ಮೌಲ್ಯಮಾಪನ ಫಲಿತಾಂಶವನ್ನು ಘೋಷಿಸಿದ ದಿನಾಂಕದಿಂದ 2 ತಿಂಗಳವರೆಗೆ ಸಂರಕ್ಷಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಮಾರ್ಚ್ 2021ರಲ್ಲಿ ನಡೆದ ಪರೀಕ್ಷೆಗಳ ದಾಖಲೆಗಳ ಸಂರಕ್ಷಣೆ ಅವಧಿಯು ದಿನಾಂಕ 9/7/2022ರಂದು ಮುಗಿದಿರುವುದರಿಂದ ಸದರಿ ಪರೀಕ್ಷೆಗಳ ಉತ್ತರ ಪತ್ರಿಕೆಗಳು, ಅರ್ಜಿಗಳು, ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆಗಳ ಬ್ಯಾಂಕ್ ಮಾದರಿ ಉತ್ತರ ಪತ್ರಿಕೆಗಳು, ಹಾಜರಾತಿ ಪಟ್ಟಿಗಳು ಹಾಗೂ ಇತರೆ ಪತ್ರ ವ್ಯವಹಾರದ ದಾಖಲೆಗಳನ್ನು ನಿಯಮಾನುಸಾರ ವಿಲೇವಾರಿ ಮಾಡಲು ಆದೇಶಿಸಲಾಗಿದೆ. This my lord covered each and everything.
It doesn't say anything about the key answers.
Lord, if
It will be available even with the person who has set the paper. Please get it.
If it is available, my lord.
A week's time is finally granted to the respondent, to the appellant. In the writ appeal and a respondent in the contempt petition to file an affidavit in terms of the directions issued on 18/9/2024. Release this matter on 20th of November.
Please.
Seal number 28, Sharan Basappa M. Patil.
Delay ilva? Huh? Delay ilva? No delay. Issue notice to the respondents. Full stop. In the meanwhile, there shall be an identity order of stay of the impugned judgment and award in MBC 142 of 2021 on the file of the second additional district and session judge and MACT at Raichur till the next date of hearing, subject to the appellant depositing 50% of the award amount before the tribunal within a period of 6 weeks from today.
Finally, seal number 29, R.S. Siddhapurkar.
Matter is called out. There is no representation for either of the parties. Release this matter.
Appear for respondent.
Either of the parties except the learned AGA. Release this matter on 25th of November.
Seal number 30, 30, Kausalgi Chandrakant Lakshman.
Huh? Delay? Delay in filing the FIR. Yes.
False involvement of the vehicle is also.
Huh?
False involvement of the vehicle. Owner has examined.
Internal page number 12. Internal page number 12, ink page number 20, paragraph number 18.
Yes.
Last sentence, Kagada. From the above evidence of this witness, it can be inferred that when he himself was admitted in the hospital for about 15 days, and thereafter he had taken rest for 4 or 5 days in his house. In such circumstances, it is difficult to believe that the above petitioner was shifted to Ashwini Hospital, Sholapur, was taking care of him till the filing of the complaint as he stated in the complaint. It is a case of injury. That is why the tribunal has disbelieved your version. Yes, this sorry. So you have said the police had come to the hospital. You informed them, yes, accident has taken place like this. But no registration. To inform, ಅವರು inform ಮಾಡಬೇಕು. Hospital ಅವರು inform ಮಾಡಬೇಕು. ಹೌದು. And in your evidence you have said police had come to the hospital, they inquired about inquired you, but still no case is registered. That is why the tribunal is disbelieving. The law requires and mandates the hospital authorities to give information to the police if there is a reported case of road accident. ಅವರು ಕೊಟ್ಟಿಲ್ಲ. ನೀವು ಆ ಪೊಲೀಸ್ ಅವರು ಆಸ್ಪತ್ರೆಗೆ ಬಂದಾಗ ಅವರಿಗೆ ತಿಳಿಸಿದೀವಿ ಅಂತ ಹೇಳ್ತೀರಾ, ಅವರು ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ಲ. ಈ ತರದೆಲ್ಲ ಹಿಂಗೆ ಇವಾಗ ರೆಗ್ಯುಲರ್ ಆಗಿ ನಾವು ಕೋರ್ಟ್ ಇಸ್ ನಾಟ್ ಪ್ರಿಪೇರ್ಡ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ಆಲ್ ದಿಸ್.
ಇನ್ನೊಂದು chief owner has given affidavit that my brother taken my vehicle to plant this vehicle. Even also the evidence is there. We have filed affidavit of owner.
ಎಲ್ಲಿ?
RW Jeep was subsequently planted. 3 and 4 mil. RW.
Allah, that will be referred to in the impugned order.
Yes, it is.
Please point out from the impugned orders. RW2. Evidence.
Evidence. Exhibit R2. R2 and R. Exhibit R3 and R4.
ಅವ್ರ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ನಾಟ್ ಬೈ ದಿ ಪೊಲೀಸ್.
ಎಕ್ಸಿಬಿಟ್ ಆರ್ ಟು ಹೇಳ್ತಾ ಇದೀರಿ ನೀವು.
ಹಾ
ಆರ್
ಪ್ಯಾರಾ 20 ದಾಗ ಎಲ್ಲ ಡಿಸ್ಕಸ್ ಮಾಡಿ.
ಆರ್ ಡಿಪೋಸಿಷನ್ ಆಫ್
Respondent deposition ಹೇಳಿ we have marked those document and it was discussed in para 20 of the judgment.
para 20.
Yes.
ಓದಿ.
In this case, the owner of the said jeep, respondent 1, remained absent and hence she has placed ex parte. When the case set out for second respondent side evidence, the second respondent has filed an application under order 16 rule 6 and 7 CPC, praying to issue a notice of respondent 1 and to produce the original affidavit dated 3/11/2014, sworn to before a notary public and to give evidence on the said affidavit. After issuing the notice on IA number 3, the respondent number has appeared before the court and she has examined as RW2. In the affidavit, she has stated that her vehicle, that is Jeep bearing MH04Q0699, was not at all involved in the alleged accident. Thereafter, her brother, petitioner relative, and police colluded with each other, have falsely involved her vehicle in the alleged accident. She informed this fact to the insurance company and also submitted 2 copies of affidavit shown before the public notary in this regard. The original affidavit were handed over to her brother to engage a counsel and to defend
producing before the court.
Yes.
Along with her wakalat.
Yes.
To engage
Counsel to defend the case on her behalf and contest the case. But recently she came to know from the insurance company that her brother has neither engaged the counsel nor produced the said affidavit before the tribunal. The said attested copy of 2 affidavits were already marked exhibit R3 and R4 through RW1. Even though she has stated that the 2 copies of affidavit shown before the notary public were given to R2 insurance company by her. But in the cross-examination, RW1 has stated that after receipt of the notice from this court in the above case, not issued, the respondent number produced the said vehicle and DL of the driver for their inspection. He also admitted that after his accident, the respondent 1 was not at all contacted them. When such being the case, the question of handing over the 2 copies of said affidavit of respondent went to.
So there are no police records also. No police records.
No.
Huh?
FR.
ಅದು ಆಮೇಲೆ after you gave a written complaint.
Yes.
ಏನ್ ಹೇಳ್ತಾರ ಅವರು ಪೊಲೀಸ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ವಾಟ್ ಹ್ಯಾಸ್ ಕಮ್?
ಇಂದಿನ ಇಂಡಿಕೇಟರ್ ಮಟ್ಗಾಡ್ ಹೊಡೆದು
ಅದು ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಆಯ್ತು.
ಅಲ್ಲ ಇದು ಮಜರ್.
ವಾಟ್ ಇಸ್ ದಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಡನ್ ಬೈ ದೆಮ್?
ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಆಯ್ತು. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ 239, 337.
ಅಲ್ಲ, ದಿಸ್ ಲೇಡಿ is saying my vehicle is not at all involved in the accident.
ಅವ್ರು ಹೇಳ್ತಾರೆ in order to escape from the liability, she can file at that affidavit. That cannot be believed.
So therefore, when did they examine the vehicles? 34. When did the accident take place? 5/4.
Complaint ಕೊಟ್ಟ ಮೇಲೆ ಫೈಲಿಂಗ್ ಕಂಪ್ಲೇಂಟ್ ಬಟ್ ಅದರ ಡ್ಯಾಮೇಜಸ್ ಇದೆ.
25 days delay. 25 days delay.
Yes.
Accident took place on 5/4/2024. ಅಲ್ಲ, ಎಲ್ಲಿ ಹೋಗಿ ಮಾಜರ್ ಮಾಡಿದ್ದಾರೆ ಇವರು?
5/4/2000 ಇವ್ರು ಮಾಜರ್ ಮಾಡಿದ್ದು
ಅಲ್ಲಿ ಏನಿರುತ್ತೆ?
ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ತಂದೆ ಮಾಡೋದು. ಪೊಲೀಸ್ ಸ್ಟೇಷನ್
ಫೋಟೋಗ್ರಾಫ್ಸ್ ಇದೆಯಾ?
ಫೋಟೋಗ್ರಾಫ್ಸ್ ಇಲ್ಲ, ಇದನ್ನ ಪಂಚನಾಮ ಮಾಡಿದೆ.
ಇವ್ರು ಪೊಲೀಸರು ಇನ್ವಾಲ್ವ್ ಆಗಿದ್ದಾರೆ.
That is how.
ಇದರಲ್ಲಿ
ಫೋಟೋಗ್ರಾಫ್ಸ್ ಎಲ್ಲಿದೆ? That is why she is saying ನನ್ನ ವೆಹಿಕಲ್ ಇನ್ವಾಲ್ವ್ ಆಗಿಲ್ಲ ಅಂತ.
133 ಕಡೆ ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ. ಆಕ್ಸಿಡೆಂಟ್ ಸೆಕ್ಷನ್ 133 They will issue notice to the owner, correct? It is the duty of the owner to furnish the name and address of the driver of the vehicle. And also the RC book. That is complied. They have not taken contention that 133 of not.
ಅವ್ರು notice issue ಮಾಡಿರ್ಬೋದು. But where is the information that we have investigated, we have seen the vehicle, this is the damages we have seen in the vehicle.
IME report plus IME report. IME report exhibit ಆಗಿಲ್ರಿ. ME report, motor vehicle inspector report. ನೋಡಿ. Plus ಇದು ಪಂಚನಾಮ.
They don't even have a photograph to show.
Photo.
ಎಲ್ಲೆಲ್ಲಿ ಹೋಗಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದ್ದಾರೆ, ವೆಹಿಕಲ್ ಫೋಟೋಗ್ರಾಫ್ ಏನು ಅದೇ ದಿಸ್ ಇಸ್ ವಾಟ್ ಇಸ್ ಬೀಯಿಂಗ್ ಹ್ಯಾಪನಿಂಗ್. ಅವ್ರಿಗೊಂದ್ ಸ್ವಲ್ಪ ದುಡ್ಡು ಕೊಟ್ರೆ ಅವರು ಬರೀತಾರೆ ಪೊಲೀಸ್. That is why it is not enough if they simply issue notice. They'll have to give proof. Yes, we have inspected, we have investigated, we have found the damage to cost to the vehicle. They'll have to show photographs.
ME report ಹಾಕಿಲ್ಲಲ್ಲ. At least they should.
There is no ME. ಹೌದ್ರಿ, ನೀವು 25 ದಿವಸ ಡಿಲೇ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಬಿಟ್ಟು now you want to put all the blame on them. ಏನ್ ಮೀನಿಂಗ್ ಇದೆನ್ರಿ? 25 ದಿವಸ ಅನ್ಕಾನ್ಶಿಯಸ್. What is this? That is why the tribunal has disbelieved. And there were two persons. One is the rider, another one is a pillion rider. ಇಬ್ರಿಗೂ ಇಂಜುರಿ ಆಗಿದೆ. IMB ರಿಪೋರ್ಟ್ ಇಲ್ಲ. ಇಲ್ಲ. No photographs. Nothing is there.
Lapse of 25.
ಅದೇ that is why expect
Damages.
that is why that is why the burden is heavy on them. You cannot shift it to the insurance company. ಹಿಂಗೆ ಇದೇ ತರ ಡಿಫ್ರಾಡಿಂಗ್ ಇಸ್ ಹ್ಯಾಪನಿಂಗ್.
ಎಲ್ಲ ಮಹಾರಾಷ್ಟ್ರ ಆಗಿದೆ.
See, when the owner of the vehicle is taking a contention, my vehicle is not involved in the accident, it will become that much more difficult for the claimant. ಅದೇ ಚಾರ್ಜ್ ಶೀಟ್ ಪೊಲೀಸ್ ಅವ್ರು ಏನ್ ಬೇಕಾದ್ರೆ ಬರ್ಕೋತಾರೆ. Without information, we cannot believe. Conviction ಆಗಿದೆಯಾ? Sir, that is why Supreme Court has also come heavily.
Recent judgment no ಬಂದದ್ದು.
There are many judgments where these kind of observations have been made by the Supreme Court.
This Supreme Court has taken a serious.
ಕೊಡಿ. ಇವಾಗ ಏನ್ರಿ ಇನ್ಫಾರ್ಮೇಶನ್ ಸಿಗುತ್ತೆ ನಿಮ್ಗೆ? ನೀವು ಮಾಡಿರೋ ತಪ್ಪಿಗೆ ಅವಾಗ್ಲೇ ಸಿಗದಿರೋ ಇನ್ಫಾರ್ಮೇಶನ್ ಇವಾಗ ಹೆಂಗ್ ಸಿಗುತ್ತೆ? Now, it is for you to defend or for you to convince this court as to what is wrong in the impugned order. ಹೌದು ಅಷ್ಟು ಹೇಳ್ಬಿಟ್ರೆ ಸಾಕಾ? ಕೊಡಿ ಕೊಡಿ, let us see. See, it depends. It depends on facts of every case. If at least there is some material which can be relied upon, yes, we will do it. But if there is no such information, credible information, just because a charge sheet is laid, we cannot believe the version of the police also. There are many cases where the Supreme Court has given directions. These type of false cases have been filed, and insurance company, they have also colluded.
Yes, Malad. Well, we are also party for it, so many cases. Again, Maharashtra problem, jurisdiction ಇಲ್ಲಿ ಬರ ಕಡೆಯಿಂದ
Correct. This is what we are saying. Let us ignore the fact that there was delay. What other credible material is placed on record? That is what we are asking. This becomes all the more important because the owner of the vehicle has stepped into the witness box and has stated, no, my vehicle is not involved in the accident. ಯಾರ್ಗೆ? ಹೌದ್ರಿ, ನೀವೇ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿಸಿ ಅವ್ರನ್ನ ಕರ್ಸಿದ್ದೀರಾ? Or the insurance company issued notice, got summoned her, and the witness has stepped into the box. What is the cross-examination? What have you elicited? What is the cross-examination of that owner of the vehicle? ಇಲ್ಲಿ ನೋಡಿ, ಈ ಕೇಸಲ್ಲಿ ಬದ್ರಿನಾಥ್ ಕೇಸಲ್ಲಿ, but the respondents did not lead any evidence in rebuttal of the evidence by the appellant. But that is not in the present case. The owner of the vehicle has entered the witness box. There is rebuttal.
ಪೊಲೀಸರು ಜೀಪ್ ಸೀಸ್ ಮಾಡಿದ್ರು. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಪೊಲೀಸರು ನಿಮ್ಮ ಜೀಪ್ ಅನ್ನು ಸೀಸ್ ಮಾಡಿದ್ರಿ ಅಂದ್ರೆ, ಇಲ್ಲ ಅದು ನಮ್ಮ ಮನೆ ಮುಂದಿತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. ಪೊಲೀಸ್ ಠಾಣೆಯಿಂದ ನಮ್ಮ ಫೈಲ್ ಬರೆದು ಕೊಟ್ರೆ,
ಅದೇ ಅವ್ರು ಬಂದು ಅವ್ರ ಇಷ್ಟ ಬಂದ ಬರ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ,
ಬಾಂಡ್ ಬರೆದ್ಬಿಟ್ಟು ಜೀಪ್ ಅನ್ನು ಬಿಡಿಸ್ಕೊಂಡ್ರು.
ಹೌದು ಸರ್, ಅವ್ರು ಬಂದು ಗಾಡಿ ತಗೊಂಡ್ ಹೋಗ್ತೀವಿ ಅಂತಂದ್ರೆ ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ ಅವರು? ದೇ ಹ್ಯಾವ್ ಟು ಗಿವ್ ಎ ಬಾಂಡ್ ಟು ಗೆಟ್ ಇಟ್ ರಿಲೀಸ್. ಚಾರ್ಜ್ ಶೀಟ್ ಇರ್ಬೋದು. So it is not resulted in conviction.
ಮೆಟೀರಿಯಲ್ಸ್ ಇಲ್ಲ ಅಂತ ಏನ್ ಕನ್ವಿಕ್ಷನ್ ಆಯ್ತಾ ಕೇಸ್ ಏನಾಯ್ತದ
Acquittal.
No, that is not bearing on this.
This is, see, this is the, in Badrinath case, this is what is said. But the respondents did not lead any evidence in rebuttal of the evidence led by the appellant. Even the driver of the truck did not enter the witness box to deny the factum of the accident. That was the case there. But here, the owner of the vehicle has entered the witness box and she is saying, no, my vehicle is not involved in the accident.
ಓನರ್ ಹೆಸರು ಸಾರಿಕಾ ಪವಾರ್.
Yes.
See, in many cases, in most of the cases, such fraud cases, the owner of the vehicle also will be hand in.
Hand in glove.
But in the
Yes,
present case,
yes.
fortunately,
Yes, ma'am.
she has said,
she
no,
come
my
with
vehicle is
the-
not involved.
She come with the true facts.
Correct. Correct. ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. Why should she do it? Brother is colluded.
Yes, my lord.
Not the owner of the vehicle. ಅವನಷ್ಟು ದುಡ್ಡು ಗಿಟ್ಟು ತಗೊಂಡು ಅವನೆಲ್ಲ ಮಾಡಿರ್ತಾನೆ.
ಓನರ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ.
ಯಾರು?
ಓನರ್ has not paid return statement.
No, no.
No, he has
Initially did not appear. That is why the insurance company got the summons issued.
Oh, summons.
After she has entered the witness box.
She issued summons. She instructed
ಅವೆರಡು ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಕೊಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. Yes. Heard, reserved. ಕರೀರಿಯಾ ಪಾಸ್ ಓವರ್.
Passed over matter, CL number 24, Anand Ture.
ಅವ್ರನ್ನ ಅಡ್ವೊಕೇಟ್ಗಳನ್ನ ಕೇಳಿ ಒಂದು ಯಾವ್ದೋ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಅವ್ರು. ಅವ್ರು ಯಾವ ಡೇಟ್ ಕೇಳ್ತಾರೋ ಕೊಡಿ. ಇಲ್ಲ